And so those are the upcoming dates for this program. And then really quick, there's an opportunity through a grant here at USC that Andrea Bells has in the Marshall School. It's, she has a grant to run an I-Core node, and they do really well what we've only done a little bit of in this boot camp, and that is Voice of the Customer Survey or the Stakeholder Interviews. So she has got something, a mini course set up at CHLA. The dates are May 21 and May 28. Tamara will send you the information on that. They've probably got about 6 or 7 teams now that are participating, 1 or 2 from this group. So some of you others may want to do this. It just teaches you a little bit about the methodology, about how to approach, how to figure out who your stakeholders are and how to approach them and how to interview them. It sort of will build after that. She's got a 2-session course, a 4-session course, and a longer 7-session course. So Daniela, it might be something that you would be interested in doing since it's at CHLA. Okay? And then we can get started with our workshop leaders, but in follow-up to this workshop, if you're interested in one-on-one sessions to talk about your team's IP, see Tamara, and she's got some slots, I think, tomorrow, for you to meet with our workshop leaders from DLA Piper. So Rick Friedman from DLA Piper is here to talk about forming a spin-out and the commercialization of your technology. So Rick, I don't know if you want to give a brief background on yourself and go into your presentation.
Brief background is lawyer in Silicon Valley. As a corporate lawyer in Silicon Valley was career number 1. Career 2 is general counsel for several companies, public software companies and some private companies. Career 3 was tech transfer, including here at USC Stevens, and now career 4 is back to private law, working, representing emerging growth tech companies and working a lot with university spin-outs. And I'm the warm-up act here. And I'm going to talk, I'm going to try to keep this to a half hour to talk about forming a spin-out and commercializing technologies through that avenue. And then the rest of this will be dedicated to Eric and Stacy talking about market. So this is what we're going to go through: choice of entity, building a cap table, how IP fits in with the spin-out, although a lot of that's going to be discussion with Stacy to be more in depth on that. Financing, the spin out, and some common startup areas. So in terms of forming an entity, we don't need to spend time on this. You know you're going to form an entity, that if you're going to spin this out, you're going to form an entity. Principal benefit is the limit liability. There are other benefits, but if you are going to take this on your own, you need to form an entity. So then the question becomes, well, what kind of entity do I need to form? And there's lots of different choices of C Corps and S Corps and LLCs and LLPs and general partnerships, limited partnerships, and like how in the world do you decide what to do? Well, most people, when they form ventures, they either do it as a C Corp and an LLC. And so without sort of giving a big lecture on all the benefits, I want to say that's probably the choice you're going to end up making is between C Corp and LLC. And so we'll just talk for a couple minutes about why you would do one over the other. So when you look around, look at the companies that are actually funded, most of them are C Corps. C Corps have an advantage. They've been around forever. They're really easy to administer. They're low cost to put in place. Everyone understands them. There's a well-established set of rules. And when you get to issuing stock to other people, whether it's service providers, whether it's employees, consultants, or raising capital, very well-known. People know how to work with it. People are very comfortable with it. And sort of less chances of really messing things up. It said VCs prefer it. Some VCs can only invest in C Corps. And it can be very inexpensive to set up. You know, that said, yeah, you can go do a lot of things on LegalZoom, but when I see people do the LLCs on LegalZoom, they tend to kind of get messed up. So the main disadvantages, the huge disadvantage with setting up as a C Corp has to do with taxes, and that C Corp is an entity that gets taxed by itself. And so what that means is that if you earn profits doing business as a C Corp and you have profits there, the C Corp pays taxes on it. And then what happens, if you want to get that money up to your shareholders, you dividend it up and it gets taxed again. So this two levels of taxation can be a real problem with a C Corp. Or sometimes when you want to reorganize your assets, it's more difficult through a C Corp. The fact is that for a lot of the more typical tech ventures where you're not maybe not even expecting to run it cash flow positive, that you're going to build it up, you're going to get maybe to product approval or close to product approval, it may sell the company. Those types, when that's the likely pattern, then being a C Corp really can almost like, it doesn't work out to be a disadvantage, because when you sell the company, you sell your shares or through a merger, the money you get in goes to you individually, it gets taxed at that level, and you never have this double taxation problem. So that's it on C Corps. LLCs, though, there are cases where it may make sense to be an LLC, that if it's a limited group of shareholders and it's not going to change, and you prefer all of the tax consequences to flow through, then an LLC may be the appropriate choice. And one thing John noted here is it's really easy, when you're an LLC, it's really easy to flip over from being an LLC to a C Corp, not the other way. But when you're an LLC, you can start out that way and then make a decision later to convert over, and that's relatively expensive. So jurisdiction of incorporation, we tend I'm not talking more about C Corps. Most of the companies we work with tend to be Delaware C Corps. Delaware has very well established law. The court system is very good. The laws are very, I'd say, user-friendly. And what happens is a lot of us, we just have really deep expertise in it because all of our companies are Delaware C Corps. I tell people it's the reason Southwest flies 737s is they know them. The staff and the mechanics, it's all very well known. And we have an office in Delaware that supports efforts. And most law firms that work in the emerging growth space tend to push people towards Delaware. Oops, wrong clicker. Also, feel free to ask questions. So, you decide you're going to form a C Corp. And so what do? What's the first thing you do? Well, you end up, you file a piece of paper with the Secretary of State, and what you do when you do that is you actually create your stock when you file it. Because in that document, that certificate of incorporation, you specify what your authorized shares are. And what I'd say is just, when we're starting companies from scratch, often we'll authorize 10 million shares of common, and the numbers just tend to work out well there, but then you create it. And the thing about creating this stock is you don't have to issue all of it. Sometimes people think, oh, I've authorized 10 million, now I have to allocate those 10 million shares. That's not the way to think about it. That's a pool of shares. You can issue some, and you actually want to leave a buffer there so that you'll have more later as needed. And you can also authorize more if you need more later. So what happens is then you need to allocate. You've got your founders, and so this is the initial thing that will happen in a company when they're getting going and getting serious is they have to have these conversations about figuring out who gets what. And there's no magic formulas for, okay, well, in this case it should be 40-30-30, in this one it should be 50-30-20. There are no magic formulas. Sometimes people just, talk to colleagues, find out what other people have done. There is a great podcast that talks about two people dividing a pie. It's called the Startup Podcast. I think it's called Startup. And there's a episode called Dividing an Imaginary Pie. And it's really interesting having sort of behind the scenes look at these two people as they're thinking and going through this back and forth, and it's going to happen now. So it's a fun thing to listen to, which it gave me more insight into the process of hearing them work through it.
Is there some structures that people should steer clear of? For example, 5 founders, each with 20% or something like that?
That's awesome. Then you can't deadlock. That's because you're going to have 3 people will rule, right? I don't think so. You know, the tough things get into if you get a pure 50-50. People ask me this question is, we're going to go in 50-50. What do we do? And, you know, that's a tricky one. The 50-50 one, there's no, you can do buy-sell agreements. You could say, we'll appoint a third director, and then you're putting the person with the least knowledge and the least stake as the decision maker between the two founders. So, you know, 51-49 is better than 50-50 to avoid that, you know, to avoid the lobby. You know, but sometimes it doesn't. So there is one thing, I'll get to the next slide about something that's really important. I'm going to keep going through this. So you decide what the allocation is, and in this I've got an example here where they decide the allocation is going to be 60-40. And people can get kind of really wrapped around the axle in terms of thinking in percentages, because it's 60-40, but then you're going to go issue someone else 10%. Well, now we're at 110%. Okay, well, where does that 10% come from? So the way to start thinking about this as quickly as possible is actually to convert these into share numbers, both sort of really in paper and then think of it in terms of share numbers. So in a case, this is what we'll do is we'll form a company and they're going to have decided 60-40. So that's going to be 3 million shares and 2 million shares. And as a lawyer, that's all I'm going to talk about is share numbers. And yeah, we're going to be running lots of spreadsheets and showing percentages and figuring things out that way. But in terms of legal documents, it's critical to talk about the share numbers, because the percentage numbers tend to get people confused, like this case where it's 60-40, you're just giving someone else 10%, and now you're at 100%. So the and the allocation of shares reflects both economic and voting interests. So this is important, which is if it's 60-40, that means when the company's sold, that's how it gets allocated, but also from a voting standpoint, that if you have a majority of the shares, then you can elect the board of directors. The board of directors controls the company and hires and fires the CEO and everyone else for that matter, but will control the direction of the company. So that's why it's important from that standpoint. When you get into getting investors in your company, these might get decoupled a little bit, where they may say, well, look, we're going to have this 40% interest from an economic standpoint, but we want voting control. Or conversely, you'll see some cases where the founders have enough clout that say, okay, I'm getting diluted below a majority interest, but I'm going to take super voting shares. So you'll see that with companies like Facebook and Google, that they were able to do that. But I would say don't try that at home, because that's more likely to scare away investors unless you have that type of clout. And often that's actually done right before. So future share issuances will come from authorized bond emissions. So once you've issued that 3 million, 2 million, that's what the shareholders own. Okay? Some people get, and the reason I highlight this, and this may be obvious to some of you, but a lot of people say, okay, well, I'm issuing 1 million shares, where does that come from? It comes from the unauthorized pool, not from the founder's shares. And you get into really bad tax consequences when you start taking shares from the founder's shares. And yet, like 1 in 4 people think that, well, I'm the founder, I have all the shares, so it comes out of mine, but it comes out of the unauthorized pool. So, vesting. This was the question Christine asked, geez, is there one thing that they should do? Here's the one thing that always makes me a little scared when people go do LegalZoom. It's this idea of you've allocated the shares 3 million, 2 million. But what if a founder leaves? What if that 40% shareholder, you had that venture, no one had quit their jobs yet, and they were going to do it. But that person, because of the reality of mortgage, bills, full-time offer somewhere else, says, you know what, good luck with it, but I'm going to go take this full-time job in Medtronic. And then, but do they get to keep their 2 million shares? And generally the thought was, well, they didn't really earn anything. They got that, you did the 3 million, 2 million on the basis we're building this company and you're going to earn these shares over time. So if you end up walking away tomorrow, it's not right for you to keep those shares. So vesting becomes an important concept. It's because you're getting the shares for future contributions, so you'll want to vest them. Now, it's also what happens is if you're something where you're going to get venture capital, the venture capitals are going to require vesting as well. If you don't have vesting, they're going to come in and tell you, put this vesting on that you think you own your shares, but they're going to say, you own them, but if you leave within a certain period of time, some of them come back to the company. So even though VCs are going to require it possibly later, always strongly recommend to founders that they do this at the beginning regardless, because they're still going to be in that same position if one of them leaves, that, well, they shouldn't really keep their shares. So this is it's kind of like putting a prenuptial agreement in place, but it turns out it's actually a pretty easy conversation that, generally the founders will say, yeah, that makes sense, I get that, and you work out a fair vesting schedule between them. And so typical vesting schedules, you might have heard this, a typical Silicon Valley vesting schedule for employees who are hired, getting paid a salary, and getting stock. They'll typically get a 4-year vesting schedule that's going to have this 1-year cliff, we call it, where it's a bit of like a probation period. So if their employment terminates for any reason within 1 year, none of it vests, they don't get to keep any stock. But at that 1-year anniversary, you hit the cliff and they get a quarter vested, and then over a shorter period, like months or quarters after that, for the remaining the 3 years left. For founders, it's often a little different in terms of vesting. One thing is, you generally are not going to have this cliff for the founders. They're usually putting in sweat equity and earning it from day one, so they'll start vesting immediately. The other is that maybe they're going to get some credit for vesting up front immediately, just for what they've done prior to a corporation. So even if they do leave, they get to keep 20% or 25% or some number that's agreed upon. And so generally, my experience when you raise this with founders early, they're like, yeah, this makes a lot of sense to do that and have that conversation. And it's actually a very simple thing to implement and put in place. So what happens is, so people get this idea, they say, well, I haven't earned it yet, so we won't actually issue the stock. That of this, it's going to vest over 4 years, so we'll issue 1 year now, and after the next year we'll issue this and we'll issue that. For tax purposes, you don't do that way because it ends up, if the stock goes up in value, you have a huge tax headache because that's treated as income. So the way this is handled is you get all the stock on day one. You own it all, and what you do is we call reverse vest, where if you leave before your stock is vested, the company can buy it back at cost, which is often fractions of a penny. And then there's this important thing, I'm not going to go into it now, there's this thing called 83B elections. I'm not going to go into the reasons and the tax law behind it, but if you do it, it's critical to know that there's this thing you got to file with the IRS if you do this reverse vesting where you get the shares. And you may have to give them back if you leave before the rest. Okay, so that was it. That was it on initial cap table. I just wanted to kind of run through that because people may be forming entities, things to think about up front as you're creating and how do I get this going. Next topic is why worry about IT. So you're forming your entity, and one thing is the IP so far has been handled within the university probably. You haven't filed it, you've gone to BJ, he's taken care of it, it's all great. It's got your patents filed, all is good. So you haven't maybe been thinking too much of it other than I need to probably get rights from the university. But once I form my entity, what do I need to start thinking about it? And I think you're all aware of these reasons that, geez, you're protecting your work. So you're filing patents, you're doing other things to protect it from copying you. Depending on what kind of claims you can get in your patent, you may be creating barriers to entry, so people can't do something similar to you when they see what you've done. It can increase your chances of being able to finance your project. That financing sources like venture capitalists are going to want to see that you have a competitive differentiation, that there are barriers to entry. And so they may be asking and say, well, yeah, you can do that, but can they try to just throw 5 engineers and just do the exact same thing and knock you out of the market? And so why would we put our money into that? So from a financing standpoint, your investors are going to want to see it. As well as, even if you're not doing a startup, if you're licensing, it's going to be the same thing. If you want a big company to work you, if you're going to commercialize the licensing, it's got to be something where something's going to be provided to them that they can't do themselves. And the last reason to think about it is, I was sort of these reasons why it's positive and you need it, and you're establishing these barriers to what you're doing and making it more financeable. But there's a defensive reason you do it also, which is you don't want to get sued by someone else. And now it's impossible to prevent that. But you want to be smart in how you're going about things so you're not walking into a trap where you're going to get up and going and you think you need traction, but you've all of a sudden got a lawsuit, maybe from a former employer or something, So those are the top reasons if you're doing a startup to be thinking about it. So let's talk. So first, I want to talk about the university IPs, and I think everyone in this room is going to be in the situation where if they're going to go to a startup, part of it is going to be based on university that's developed within the university and owned in the university. And Eric's going to talk a little bit about what that means, university ownership, and how that's defined. But I'm going to posit for now that all of you are going to have something that in your venture that is university owned. And so the typical way of commercially exploiting that, I think as you all know, is that it needs to get licensed from the university. And whether you're doing it as a spin-out, or you're going to license it in your spin-out, or a company's going to come along and license directly, there's this mechanism for licensing. And a license agreement covers many things. First of all, it provides a grant. So if you're running a spin-out, this license is going to grant you the right to use existing technology, and I should have highlighted that word existing. Now, when you enter into this license with whatever, whether it's USC or CHLA, wherever you may be working with, it's going to cover technology at one moment in time at the time you do the license. So if there's further work going on, further improvements going on in your lab, that's a consideration to talk to your licensing office about what are we going to do if there's future IP, because we're capturing it at one moment in time. There are occasions where you can negotiate ahead of time for future, but they're kind of rare. So you're licensing what exists now in terms of things that are already being developed. You're getting a right to use that. Often,
sorry, just to touch on what you just mentioned about future rights or future research coming from the same lab. It's rare that academics agree to that. Some of us do it.
you mean to the tech transfer office?
Yeah.
I think practices vary. Like Caltech is very, Caltech will agree on front. Caltech is sort of very used to that. Sure. UCLA says, no way. It's go to Oakland, go talk to people up in Oakland, can't do it. Come back to this later after it's developed when we issue a license. Then other people maybe, someone know, I don't know what the USC's current practice is. And I think it's a little tricky to establish that. But, practices.
And here's I just want everybody to hear this. There's a question with intent. Can the licensee pay the university to stop doing further research in that lab?
They try sometimes. So in my experience, universities are very lax to permit, to allow any restrictions on that. That's my.
Yeah, I think the general mantra is that payment would have to be non-trivial in order to get some traction.
Yeah.
Because the university's primary mission is the research dollars coming in today versus an indeterminate amount coming in the future, right? So you have to offset any research grant and overhead that the university would get, right? And anticipate what that is, and that's going to be, I think that's a pretty rich process.
Frankly, I've never seen it.
Yeah,
I know situations where people really wanted it. It's like they've got their molecules, they want to get these to market, they don't want competitive molecules being developed, whatever it is. They don't want anything.
I think in USC the check would have to be rather very large before somebody, and then you still never do it.
I'd be surprised because one of the things that goes in the license, and that's noted here, is there's always the reserve rights to the university, which seems sacrosanct.
Thanks.
So it's this grant of rights. It's often exclusive, which means that the university is not going to grant someone else the license. And then you get into interesting issues where it also means that someone's going to be able to sue other people who practice the invention, and that's some falls between the university and licensee where that comes out of the license. But as I noted earlier, the university is almost always going to retain rights for research and education purposes. So part of this deal of getting the exclusive rights from the university is that you have to go commercially exploit it. And yeah, you're all the teams that it's your research, you're going to do it. But for the university, this is important because the reason they're doing the licensing is to get this technology out in society for practical application. So it's mandated in the license that you go use your diligent efforts to develop and bring the technology to market. And not only is there a general obligation, but there are often, I think, in almost all cases, are going to be specific milestones with specific dates, depending on the kind of product, but moving you along the product development roadmap to a commercial product. And the university expects to get paid for this. And there's often a combination of payments that trade off against each other. Certainly for patent products, certainly for medical devices, there expects royalties, spin-outs, there's often an equity component. Generally, the licenses allow sub-licensing, so there's sharing of sub-licensing income. There may be certain fixed fees. There may be milestone fees, so that if you get, your approval or get product to market, those may trigger some payments and patent cost reimbursement goes to all institutions for the licensing and pick up costs. Pick up prior costs, maybe right away over time, but also pick up current patent prosecution costs.
Rick, could you talk a little bit about money flowing back to the university and where it goes?
Eric, I'll let Eric take that.
Oh, okay.
Eric's got a slide.
All right.
Then, if it's federally funded, there's this thing called the Bayh-Dole Act, which the great thing about the Bayh-Dole Act is it gives the research institutes the ownership of the technology that's developed at them. There are requirements that go back to the government, including manufactured in the U.S. for products to be made and sold here, and the federal government maintains some rights in the technology. And this is, we're talking about this idea of a license. In some cases, before going and doing the full-blown license, a lot of companies will choose just to do an option and enter into an option agreement with the university. That's not the license yet, but just says, look, we, the university, agree we will license it to you on these terms if you so elect, and often have a term sheet attached to that that'll have the physical economic terms. And then that gives, that allows the company to delay licensing, which they may want to do for costs or for some other reason, but gives them the credibility that the technology is locked down and they may be using that out talking to investors or team members as they're pulling everything together. So that was, this slide was about the university-owned patents and other IP. I didn't really touch, there may be other things that the university just want to mention, talk a lot about patents, but there may be other things within the university that are of commercial value that are technically owned by the university and you want licensed out. It could be that you might have written some software that's used to drive something. A lot of times people will just start from scratch on that software when they start in their entity. But if not, if they want to leverage some of that, then they'll take a license to that as well with the patents. There could be other technical information going into the products that they want licensed as well. Okay, so now that was the university side of it, and that was the idea of, okay, the university's got them some things of value, we're going to license it in to give us, because we need it for what we're doing, plus it gives us a jump start on what we're doing. Now, within the company, what are you starting to think about as you establish your startup company? What are some of the basic things to be doing to start about IP? One of the very first things is to be thinking, I actually didn't know that here, but there's really two things. There's agreements you do to protect it. One is non-disclosure agreements, where when you're talking to people about ideas that may not be out there, is you get them under confidentiality within a non-disclosure agreement. The other one is that you get written assignment agreements with everyone who's working on your technology. Make sure you're assigning the ownership into it. So to the extent you have money in the entity and you're paying other people to do the work, is you want a written assignment to make sure you have clear title to everything that's going into your product. And there's very standard forms that we on the office we give to our clients. Say, here's the forms. If you're an employee, they sign this. If you have an independent contractor, consultant, advisor, this is the form we sign. take measures to keep, oh, I did mention NDAs. Take measures to keep trades, to keep secret secret. Eric's going to talk a little bit about trade secret law, and one of the things with Natalie to bring into the startup is about if the extent you're being relying on trade secrets is the discipline around that. I'm not going to talk about patents now, because that's going to be well covered soon, and maybe trademark protection. So, avoiding issues with third-party IP. So we talked about, so first we talked about universities got IP, what you're going to do with the company to secure your own IP. Actually, did I mention this in this previous slide? Oh, yeah. Actually, I want to just highlight one thing. Consider patents for company developed inventions. Once you get into your own company, if you're putting money in, that, you're getting SBIR money, whatever it is, you now need to start thinking, okay, BJ's not going to file my patents anymore for that. This is something that's done at the company's paying for. This is now company property, not university property, probably. So you need to start thinking, okay, I need to be talking with my own patent people about and thinking about it, about independent inventions that may be coming out of it. Okay, so finally, avoiding issues with third-party IP. Just a few questions to ask. Has all the product development been from scratch? Or have you received any elements from other parties, including companies you or other team members may have worked for? That's a sort of a dangerous one. There's some laws working with the company now are being over, and that needs to be analyzed into a situation like that. Or if you're doing software, you maybe downloaded elements from the internet, you take some software, open source, you say, oh, I can just go use that. Yeah, maybe, maybe not. Depending on the open source license, it may create problems for you in terms of the rights that are associated. Yes, if something's open source, you are able to use it, but it may make something you thought was proprietary to you, maybe something you actually have to share with the world, if it's in the wrong licenses. If there's been work you've done before you form the company, work you've done that will need to get assigned to the company. I just throw this out here, should you go through an operating analysis? I'm going to actually just leave that as a question. I'm going to just leave that there because Eric and Stacy spend plenty of time on other people's patents. Okay, and that was it on the IP, sort of things to think about from an IP perspective as you're forming a company. A minute on financing. Often when companies are going out, I mentioned at the bottom of this slide this idea of non-dilutive financing. A lot of the researchers here are familiar with government grants and getting SBIR money in. That's a great way to be able to finance your spin out if you can get it. It's non-dilutive. Sometimes it's possible to get customer financing if you're far enough along that people can pay. But otherwise, you might be looking for financial investment from other sources. People who are investors who are investing in it to make a profit. And a frequent way to start is this idea of seed investment. Seed investments often sort of $250,000 million, and people for that, often the best sources end up being friends and family these days. There are angel networks that you can tap into, but the way financing is working, often they're coming in a little later now. So this can be a tricky place to get financing. But those are kind of the typical sources of friends and family and angels. Sometimes you also will find early stage venture funds, but the venture funds tend to be later. I'm going to talk about in a second that convertible debt is in vogue. Back not that long ago, investment always came in the form of stock initially. Now there's convertible debt, and I'll talk about that on the next slide. And then when the venture capitalists come in, usually a little later, things are more developed, and then take more stock. As I mentioned earlier, the equity financing is going to dilute all the shareholders. So we've issued those $3 million, $2 million to new founders. More stock comes in, it increases the overall pool of outstanding stock, and dilutes everyone. And as I noted here, including the university, which may be a shareholder by now, if they've taken equity for their license. So okay, now I wrote this. I just want to mention convertible debt really quickly. It's come in vogue in about the last 5 years of companies using this to fund it. So if you are out funding, it's it's actually maybe more likely than not, if you're getting investors at an early stage, that you're going to end up using convertible debt. And just really briefly, convertible debt it's debt, it's a promissory note. And the terms of it is that it will convert to stock when you sell stock of at least a certain dollar amount. For being in earlier, it's going to be at a discount, so often they'll get a 20% discount. There may be a cap on the price they have to pay, though, generally a low interest rate. It's fast and simple. It doesn't require you to actually put a value on the company, because you're saying, well, we don't know what the value of the company is, we're not going to worry about it. It's going to get valued in the next round. And again, easier, you can just start taking money right away. It's a real advantage over some very expensive preferred stock. You can authorize it, file something with the Secretary of State, much simpler than that. And although it's debt, most people, when you think of debt, like promissory note, something you give your bank, give your bank a promissory note, and they give you money, the bank expects to get repaid. With this kind of debt, that's not the expectation. The expectation is it's going to be funded later. I think I'm going to skip over this. Just I want to make sure we have enough time for the key stuff.
What happens when you don't achieve the next round of financing? Or
there's various ways. So there's two, if one of the mechanisms is, like, if you actually get acquired first, so it could be that you get acquired before you do the financing, there's usually a mechanism in there. Often you just pay back the debt at 50% or 100% premium. In that case, that's a negotiated term. If it turns out you go 2 or 3 years and you end up cash flow positive, a lot of investors will negotiate that they can, at their option, convert and put a valuation in there that if you 2 or 3 years from now don't get that financing, then at the option you can convert. The other thing that will happen is what I'll generally say is it's payable upon demand then at maturity, which is often about 2 years out. So what happens is that the investors, when you get there, they can either demand repayment, or they can just say, we'll wait till you do your next financing. And I just put up a sample cap table, so this is what it looks like. You've gone and let's just say you've agreed to give the university 5% after financing. You set up an option pool, 10% is kind of common. And some investors have said, look, we'll give you $2 million. This is assuming you did a preferred stock investment. We'll give you $2 million at a $6 million pre-money valuation. Not going to spend a lot of time, but $2 million on a $6 million means post-money valuation is going to be $8 million because it's 6 plus 2. Do some quick math here. So that's 2/8 that they have in 1 quarter. So the investors would end up with a quarter of the stock, and that's what dilution would look like. So founder A and founder B that started at 60%, 40%, at that point would be at 36%, 24%. And the university's got a bit for the license. There's an option pool that you're going to use for employees, advisors, board members, others, and then investors pay 25%.
This I know is a little bit a future type of question, but investors usually request to own a percentage of the company. And if you're an inventor and you've added value to your company, there might be either the percentage, but then there's a dollar amount, right? And so will investors either, so if they say, I want to own 25%, like, well, actually, I'm worth $20 million, so the price to get it is higher. Are investors more inclined to either raise their contribution to get the percentage, or are they willing to take a small percentage and stay with their dollar amount? What do you think?
From what my sort of hearing is sometimes they really want the percentage that they're willing to, if the company is.
So
That's sort of I don't know if you heard.
Yeah, I was trying to get, I hear both versions of people saying that their philosophy is to get X amount, and then they see they have the money for it, and if they don't, if they like the deal, I was wondering if they usually lever up or they settle back. So that's what I was
And I think it is a philosophy. I'm sure it's going to depend investor to investor, but some have their we have 30%. So yeah, that's any questions on this? And I think what's my last slide? just some things that I was like, things that I see people doing early, I just like to.
Actually, a quick question on that last cap table is, so what we do at the university is that we have a kind of anti-dilution, right? We hold ourselves at some minimum valuation. So how does a team calculate that if that valuation is kind of above that anti-dilution threshold percentage, right? So you get 5% up to half, raising equity, or you're worth $1 million, but then we do a round that says you're worth $8 million. How do you
So
adjust that?
usually the way it's structured in the license is it doesn't do it based on the valuation, it does it based on the amount raised. So you always have to make some assumptions to see what your future dilution is going to be. But so when these founders are getting together, they could be thinking, geez, we really think that we could raise $2 million on a $6 million pre. That's what we're hearing in the market based on our stage of development. So they could model these numbers out. Now, if it turned out that they were wrong, we could see which way wrong and how those numbers go and play with that. It's pretty easy to model once you set that up, because you're ultimately, I can share a spreadsheet.
All right.
Okay, finally, 9 takeaways of common startup errors. One is delaying the founder's stock issuance until the company has value. You want to get the stock issued early. It's sort of as early as you can divide the pie between the founders is actually getting the stock issued, because then it's going to have close to little or no value. You want to do this before the license is negotiated, maybe long before. Just so you know, when you're putting your money in, there's no value, so there's, it should be minimal or zero tax consequences. Second one, not impose investing on founder shares. Again, I've seen situations where someone leaves, there was no vesting, and creating problems, not having to try to get those shares back. I'm just going to leave that kind of through the election in there, and when you get to it, when you get to the point of needing to know that, then I or your lawyer can explain to you why you did that file. Not locking down intellectual property, getting those agreements earlier. You started the company, you started the discipline of getting assignments from everyone. What you want to do, so this is getting stock options. When you want to start giving compensation to people, you want to talk to your lawyer about putting a proper plan in place and doing it correctly to avoid some issues with your stock option plan, and generally with a stock option plan in place. Treating founder stock grant as the piggy bank, that's what I said earlier about when you've issued the 5 million shares and then you're going to issue someone else, they don't come out of your founder shares, that's how they allocate the pool. So you're the founder, you have your shares, you keep your shares unless there's vesting. Paying success fees for helping with fundraising. It seems like half of my clients decide this is a brilliant idea and don't realize that they're violating federal securities laws. So now I try to tell people earlier about this, that if you say, oh, my friend said they give you money, I told them I'd pay them 5%, unless they're a registered broker dealer, it can't do that. It creates problems down the road. We've talked about don't document share issuances in terms of percentages. You want to be talking about numbers. Selling stock to non-accredited investors. Your lawyer will help you with this, which is when you're actually selling it and receiving money for your stock, you're going to want to deal with people who are meeting accredited investor standard under securities laws. There may be some changes. There's a Jobs Act that once there's some rulemaking under it, will loosen this up a bit, but that's been long. I think it may change. Okay, any questions we can talk about?
Okay, all right, so I'm not sure if Eric or Stacy is going next, but just a couple quick announcements. There's some refreshments on the side, and they'll be coming in a little while. And then I also wanted to introduce a special guest, Ruben Flores from LA Biomed, who is also on our oversight committee. So he will be one of the reviewers of your proposals. Ruben, I don't know if you're available from 5 to 6. The workshop leaders hang around from 5 to 6. And
I'm planning to stay here.
okay, so if you would like to run your proposal by Ruben or get some advice from him, he's here. So please take advantage.
I do this. Oh, thanks.